All right, hello. Welcome once again, Disability Law Show. John Scholes, James Fireman. Good to have you along again this week. So much to cover, so we'll get right at it. I'll give you the reach out right away, 1-855-821-5900. You can call that number anytime. Get a hold of James, a member of his team, have a discussion. Lengthy or otherwise, they're always there to help you. help@disabilityrights.ca is the email address. We will be referring to that several times throughout the show and some other things. And the topic for today is 5 common LTD terms and how they can impact your claim. That is all in the near future. But first, we'll get to a little bit of a week that was, my brother. How are you today?
Oh, I can't complain, John.
Good.
So today I want to talk about reputation and how important it really is in the entire LTD process. So I want to talk about a file that I recently resolved, and it was a client who came to us after being with another firm. His previous lawyer had reached out to the insurance company trying to resolve the case without having set up a mediation. And the number that came back was far too low for the case. I found out later what that was. And so it didn't resolve, and the client was frustrated and eventually called us, retained our firm, and I was put on the file. And so soon after I took over the case, I had a phone call with defense counsel. She wanted to speak with me, and we had a discussion about the case. And what I was told is, she said, this is what I presented to the previous lawyer, and this is how much we got, and that's all that there is. And I said, well, okay, I guess we're just going to have to go to mediation, and we'll go from there. And so a few months later, we were able to get to mediation, and I went through the entire file quite thoroughly. And what do you know? We get to mediation, and it resolves for more than double what I and the previous lawyer had been told was the absolute limit. More than double. I'm not going to get into what the numbers were, and it doesn't really matter for these purposes. And so you might be asking, well, why is it? How is it that I was able to get double and the previous lawyer wasn't? Well, part of that is reputation. Part of that is, we are known by insurance companies as a firm that is willing to do whatever is necessary in order to get our clients the full value of their claim. We will go to mediation on every case, and if there isn't a reasonable result there, we will take it past mediation. And in those rare cases where the insurer is still not being reasonable, we'll take it to trial if we have to. Now, nobody wants to have to take it to trial if it can be avoided, but it's important that insurance companies understand that if it doesn't get resolved, that's where it's going to go, and we're prepared to do that. And that's something that our firm has built up as a reputation. Insurance companies know that we're prepared to do that. And so when we take over a file, things change. And it's really important to understand how files are valued on the defense side. When a file is moved from the claims department to the legal department, when a legal claim is started, there's a value that's put on that file. It's called a reserve. And that generally is what controls how much money the insurer is going to pay out on that claim, or what the most amount they're going to be prepared to pay is. Part of the analysis is who's on the other side. What are we going to have to pay to get this resolved? And a big factor is the law firm representing the plaintiff. And if the insurance company believes that the law firm representing the plaintiff is not going to be prepared to do whatever is necessary, it's not going to be aggressive about going through the file, is not going to be prepared to go to mediation and beyond if necessary, then they're not going to give nearly the full value on the file. And that's exactly what we see time and time again. I don't know if it was because I was on it or the firm, or perhaps it was something to do with the other firm that was there. But all I can say is the result was significantly better as a result of a willingness to go to mediation and, if necessary, beyond.
So would it be fair to say that if an insurance company gets a claim from said law firm, Samfiru, Tumarkin, for example, I mean, would they look at the back of that claim and right away say, whose name's on the bottom of it?
Absolutely. So,
wow.
Most of the lawyers in our group started out doing defense work. And certainly I can tell you that is the very first thing I would do. I would get a new file, and before I even read through what the file is about, I want to know who the lawyer is on the other side. I want to know who I'm up against. What is their firm and who is the lawyer? And based on that, now I've got context for this claim. Because whatever the claim is, if the law firm and the lawyer on the other side have a reputation for trying to get quick settlements without really pushing things, then you know you're going to be able to get away with paying a whole lot less than the file is actually worth. So that is absolutely a factor in how insurers are going to value a file.
It seems like beyond the name on the bottom of the last page of the claim, it would seem that there must have been some other nuances in there because obviously you're very skilled, but to double that amount, I mean, there must have been things that other lawyer completely didn't look at or missed or went over their head or they didn't pursue or pressure the insurance company with, no?
Well, I certainly can't speak to what the other lawyer knew or had gone over. All I can tell you is my process, which is going through the file in detail. I go page by page. And what I do is I create a chronology of exactly what the insurer knew and when. And I try and figure out what corners did they cut? What did they do that was not fundamentally fair? How did they act in bad faith? And so when we get to mediation, as in this case, I was able to present a list of here are all the things that I found in the file that you did that were improper. And if this case ever winds up in front of a judge, this is going to be aired in public. And that gives the insurers a whole lot of incentive to become reasonable really quickly.
Again, email address help@disabilityrights.ca. We'll get to one in a few minutes, but I want to throw another website at you just for a moment called pocketemploymentlawyer.ca. You're thinking, John, why are you throwing me an employment law website? Because there's a robust section in there on disability law, and our other show, the Employment Law Show, obviously with Lior, we refer to that all the time. But if you have questions, you want to learn more, pocketemploymentlawyer.ca. If you're dealing with an insurance company, disability woes, there's a disability law section at pocketemploymentlawyer.ca. I just want to throw that out there. Free and anonymous. Go ahead and use it. But email. First one for today. James, here we go. Brian says, the insurance company said I'm not eligible to receive LTD. The adjuster claims I don't have enough evidence prior to my mental breakdown last year, despite a long list of GP and psychiatrist appointments, as well as reports from specialists. How is that possible?
Well, it's really hard to say without having seen this file in any detail, without having seen any of the medical reports. It's possible, even with a really, really thick medical file, that there just isn't enough evidence in there that shows that someone is actually disabled from work. You can be getting all kinds of medical treatment, but that doesn't necessarily in and of itself mean that you're disabled from work. But on the other hand, let's assume for a moment that what Brian is saying is correct in the sense that he's got a thick medical file and it shows that he is fully disabled from work. All of his doctors agree he can't go to work. There's no question if anyone objective is looking at it, and yet it's still denied. How is that possible? Well, we see this all the time, and this is simply about what is the incentive for the insurance company. They're in business to make money. We know this. How do they do that? They do that by cutting off claims as quickly as possible. They take in money for premiums, and they want to cut off claims. So they're going to look through the file. They're going to try and find any justification that they can, superficial or not, to paper the file so that they can say, okay, you're not qualified, you don't meet the test. You don't meet the test for total disability. And it's especially an issue when you're talking about mental health claims. Now, we've come a long way from where it was, 20 years ago, even 5 years ago. We've moved quite a long way, even in the legal field, but we're not there yet. We're not at the point where mental health claims are treated the same way physical claims are. They are still treated more skeptically, and it is still obviously more difficult to prove when you can't show objective black and white evidence. There's no x-ray that shows depression or anxiety or PTSD. There are things that you can do that make the case a whole lot stronger. You can show that you've gone through all treatment that has been recommended, that you've aggressively pursued all of those options, and that you have whatever testing can be done in order to support your claim. But rarely is it ever going to rise to the level of black and white evidence that you see in a lot of physical cases.
Would it be fair to say that even in Brian's case, with a robust file, with backing of his GP, psychiatrist, et cetera, that the insurance company might just kind of play the odds and say, if we turn this guy down, he's not going to come back and fight, he'll turtle and walk away?
Yeah, I mean, that happens all the time. I don't know that that's happening in Brian's case. Obviously, I have to look at the file to be able to assess it, but it wouldn't shock me at all if that were the case. We see that all the time. The insurers many times are going to deny claims that they know at the end of the day is a valid claim, but they have a superficial justification, and they're banking on the fact that most people, when they get that, aren't going to bring a legal claim. Some may appeal and then eventually drop it, but most aren't going to go and talk to a lawyer, bring a legal claim, and really force them to come to the table and be reasonable.
Good start, but we got to take a short break. When we come back, 5 common LTD terms that can affect your claim. That is on the way. Reaching out in the meantime, 1-855-821-5900. Help at disabilityrights.ca. We'll continue. Disability Law Show. Stick around. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. they know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. Alrighty, welcome back. Disability Law Show. Samfiru, Tumarkin, the most positively reviewed disability law firm in the land. You can check that out. I tell you true. Reaching out is simple as well. Disabilityrights.ca is the website. help@disabilityrights.ca, the email, which we just used in the first segment, and the phone number, of course, is always perfect. 1-855-821-5900. James Fireman again alongside this week. 5 common LTD terms, pal, and how they can impact your claim. The big one, whoever came up with this first one is a genius. Total disability.
Yeah, so this is basically, LTD 101 here. So let's talk about these terms, and total disability is a perfect way to start us off. So total disability is the term that insurance companies use as the test for whether or not you're entitled to benefits. And so they say if you are totally disabled, you're entitled to benefits. But what does total disability mean? Well, most people, when they hear that phrase, they think about how it is commonly used, how they would use the phrase totally disabled if they're talking with a friend or loved one. And in that context, most people think of it as meaning that you can't do anything, that you are essentially bedridden. You can't get yourself out of bed, change your clothes, go to the bathroom on your own, feed yourself, feed your goldfish, whatever you're talking about. Most people, when they conjure up the image of someone who's totally disabled, that is what they're thinking about. That is not what it means in the long-term disability context. What it means is very precise, and it can be found verbatim in the policy. Look in the policy, and that says exactly what total disability means. All it means when you're talking about long-term disability, John, is that you have a disability that is preventing you from being able to do your occupation during the first 2 years and any occupation beyond that. That's all that it means. So there are plenty of people who have a disability that are going to prevent them from being able to work, but are still able to do many other things. They're able to get themselves out of bed. They're able to do their own grocery shopping. They're able to dress themselves and drive themselves around to appointments, maybe play a round of golf. But that doesn't necessarily mean that they're able to go to work 8 hours a day, 5 days a week, 50 weeks a year. And so that is what the test means. It has a very precise meaning. They use this term specifically to confuse people. There is absolutely no other reason why they came up with total disability as the term for the test of whether or not you're entitled to benefits, because most people will think of it as being much more severe than what it actually means in the policy. Most people, when they get a denial letter that says, we found that you're not totally disabled, they're going to say, I mean, I guess that's true. I'm not totally disabled. I can do a lot of things.
Walk and sit and do other things.
Right. I guess that means I'm not entitled to benefits. That's exactly what they want you to do. So don't do that. Totally disabled has a very specific meaning. All it means is that you can't work. If your doctors have told you you're not able to go to work, then you are totally disabled under the long-term disability policy. Full stop.
Term number 2 is this: own occupation versus any occupation. Break them down.
Sure. So this is the change of definition test. So I've already sort of hinted at this when I was talking about total disability. The test for total disability during the first 2 years is whether or not you have a disability that prevents you from doing your own occupation. So the first 2 years that you're entitled to benefits, that's the test. Total disability means you have a disability that prevents you from doing your own occupation. After 2 years of receiving benefits, the test changes. Now it becomes whether or not you have a disability that prevents you from doing any occupation that you're qualified for by training, education, or experience. But more than that, the insurance company has to be able to show that whatever job they say that you're going to be able to do, that you're qualified to do by training, education, experience, you have to, of course, be medically fit to do that. and it has to pay you a commensurate wage, which means generally that it's going to pay you something in the range of 60 to 65% of what you had been making before you became disabled. A good rule of thumb is that if you're able to make the money that you are getting in benefits or that you're entitled to receive in benefits, then you probably no longer are going to pass that test after the 2-year mark.
We've often said in the example, I think, before on the radio show as well, which can be found at disabilityrights.ca if you want to catch our radio show. You take a concert pianist who's burned both hands, cannot do his gig playing a piano, so he is totally disabled in that regard. He can still feed himself, he can still dress himself, walk around. But after that 2-year mark, maybe he can teach, maybe he can be an instructor, something like that. Would that be the type of thing we're talking about?
You got it. I think actually for the next segment, maybe you should just take over. I think you've absolutely nailed it, John.
Terrible idea. Number 3, what is a recurrence clause?
So the recurrence clause is a clause that's found in the policy that allows you to attempt to return to work, and if you're not successful, to continue with your benefits. So let's say you've been receiving your disability benefits for 8 months, 10 months, and you're starting to feel better, and you think, okay, I can give it a shot at returning to work. Your doctor says, okay, here are the guidelines, here's your limitations. You have to start slow and generally build your way up. And so you take a shot at returning to work, and you go and you're there for 2 weeks, 4 weeks, however long it is, but you realize that you're really just not able to do it. Maybe you're not able to progress past a certain point, or maybe just going back at all has made you regress or has made your situation worse. Whatever it is, you realize that you are not better yet. You're not ready to return to work. So what this recurrence clause does is it allows you to go back onto claim and to continue receiving your benefits after that attempt to return to work, which is important because for most long-term disability policies, there is a period before you get paid benefits. It's called usually the elimination period or the qualification period, where you are not actually receiving benefits. It's sometimes 4 months, sometimes 6 months, but you have to wait for that period before you actually start getting benefits. If you engage the recurrence clause, you don't have to wait for those 4 months or those 6 months. You're entitled to receive it as soon as you stop working again. But here's the thing, it's in there and you have an entitlement to it, but that doesn't mean the insurance company is always going to abide by it. More often than not, what we see is that people attempt to return to work, and when they're not successful doing it, the insurance company refuses to put them back on claim, and they'll take the position that you are no longer disabled from work and that either you didn't try hard enough, or maybe there's a modification that's available to you, or you have to attempt for longer. Whatever their justification is, more often than not, we see when people try engage the recurrence clause, they're not successful. The insurance company won't agree to put them back on.
And again, this is why you need a strong medical team behind you. Right?
Absolutely.
Hey, he tried or she tried, she can't do it. She's not ready yet.
Yeah, I think that's really important, but that doesn't necessarily mean that the insurer is going to listen to it. Yep. What that does is it puts you in a much better position down the road if you have to bring a legal claim to challenge the denial.
We were talking about 5 LTD terms and how they can affect your claim. Number 4, the old pre-existing condition.
Sure. So a pre-existing condition is something that a lot of people are very concerned about because many people are suffering from chronic illnesses that eventually become significant enough that they're not able to work. But for most people, even though these conditions often pre-exist their insurance, it isn't going to be a problem for them. There are only very specific circumstances where a pre-existing condition is going to prevent you from being entitled to benefits. You have to look at your policy because there can be some variance here, but in most policies, if you have been working at your job for more than a year, it doesn't matter whether you had a pre-existing condition that is making you disabled. In most cases, it is only if you become disabled within the first year of becoming insured do they look at whether or not your disability is something that you had before you became insured. So let's give an example. Let's say you're starting a new job, you become part of their group insurance package, you get this long-term disability policy, and then 6 months later, you become disabled from diabetes, which you've had for 10 or 15 years.
Right, good example.
Well, if that is the case, if you have been receiving treatment over the last 10 or 15 years and you become disabled for it within the first 6 months, in most policies, that will mean the pre-existing exclusion is engaged. But let's alter that scenario a little bit. Let's say you started a job 15 years ago and you've been dealing with diabetes your entire life, even before the job, and now all of a sudden it's just become too severe and you're not able to continue working. Well, you've been there well past that 1 year period. So in that scenario, it doesn't make any difference whether or not it's pre-existing. You're still entitled to your long-term disability benefits. The pre-existing exclusion would not apply.
So in that angle, you would say, if not for this job over the last 15 years, I may have not had a situation where the condition has come up.
Well, it doesn't really matter what's causing it. The only real issue is whether or not you have something that's disabling, and if it occurs within the first year, then they're going to take a look at whether it's pre-existing.
Last one is this, transferable skills analysis.
Sure. So this is something that we see as people typically are approaching the 2-year mark, or sometimes just beyond that any occupation period. So transferable skills analysis is a tool. It's a report that the insurers will generate that will allow them to take a look at your training, education, and experience and find other occupations that you may be qualified for. And so typically speaking, you do see this right around that change of definition time when the test changes to any occupation. But when we see these reports, these transferable skills analyses, we invariably find that they are missing all kinds of important information. Oftentimes, there is very limited to no information about the medical limitations and restrictions that the person faces. And very frequently, we're going to see that they're going to disregard whatever they know anyway and come up with jobs that are completely inappropriate. And even when they don't, it is almost always the case that we find that they make assumptions that you're going to be able to earn the average amount for someone in this position that you've never been in before, when the reality is, if you're starting a new career, a new occupation, virtually everyone's going to start at the bottom. And when you take a look at the lower end of the pay scale, it's almost always going to be below that commensurate income that I've talked about, that 60% of what you had been making before you became disabled.
Again, it's the transferable skills when they give you a laundry list of possible jobs you could do. Is this something you have to go back to your medical team and say, what do you think? Are we good?
So it's helpful if you're provided with a transferable skills analysis. Right. But more often than not, what happens is the insurer will get the report, and then based on that report, they're going to come to a decision about your claim, and oftentimes they'll use the findings in that report to justify terminating your benefits. And then they may give you a very brief summary of what was in the report. Most people don't even see that report until they hire a lawyer and we get the entire file.
That's all 5. If you want to reach out to any confusion to James, 1-855-821-5900. One more website I'm going to throw at you, mydisabilityquestions.com. Again, it's anonymous. You can use that anytime. Ask questions to James, a member of his team. There's a searchable database too, right? Which means your question may, in some close form, have been asked and answered before. If so, you got your answer. If not, leave your question there. It will be answered. We're going to go to that website. We've got to take a short break first. Reaching out again, 1-855-821-5900 and help at disabilityrights.ca. Stick around. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. A few minutes ago, Disability Law Show. James Fireman and his team, 1-855-821-5900. Help at disabilityrights.ca. I did mention before we cut off there for a moment, mydisabilityquestions.com. That is the website we are going to now. Shanae writes in, or Shanae. James, here's how it goes. Says, I'm a graphic designer who was recently diagnosed with young-onset Parkinson's disease. I initially tried to continue work, but the tremors and the accompanying depression and anxiety have made it impossible. My claim for LTD was denied because I was not, there you are, totally disabled. What can I do?
So I want to talk about this a little bit more broadly because Parkinson's disease, as we know, is a progressive condition. And so there are many people out there that suffer from Parkinson's or other progressive diseases. And there's a very specific mindset that you have to have when you're thinking about long-term disability claims that involve progressive conditions, because inevitably those conditions are going to get to a point where you're no longer able to work. And so we actually have a lot of experience as a firm dealing with Parkinson's claims. Savon and I very recently met with a young onset Parkinson's group. We spoke to, I think, about 35 members, all of whom were at various stages in the disability context. And that is something that we do with any group that's interested in talking with us. It's a free service that we're happy to provide. So if that's something that interests you, by all means, contact us and we're happy to provide that service. In the context of Shania's question here, so what we have to think about is, what is the insurer's interest here? What are they thinking about? They know Parkinson's disease is a progressive disease. And Shania is part of a young onset Parkinson's group, so I'm assuming that she's relative, or I'm not sure if Shania is a he or she, but I'm assuming that Shania is relatively young. And let's say Shania is in her early 30s. That means there's 30 odd years of benefits remaining. So the insurer is looking at 30 years of benefits right in the face, and they do not want to pay that.
Nope.
So they are going to do everything they can to avoid the start of paying that and hopefully paying that at all. So what are they going to do? They're going to find any justification that they can to deny this claim. And that is not at all surprising, because their liability here is likely enormous, sometimes into the 7 figures when you're talking about a claim that goes over 30 odd years. So it doesn't take a whole lot when they're faced with that to find some justification. And what they're hoping is that Shania is just going to go away. That's what they want. They want Shania to take a pass, to get frustrated with the process, to say, how can this possibly be? I've got Parkinson's. How can they not see that I'm disabled? And get frustrated, maybe appeal a few times and get more frustrated, and hopefully leave the playing field. That's what they want her to do. Mm-hmm. But you can't do that. You have to bring a claim, because if you're suffering from a disease that is preventing you from being able to work, especially a progressive disease that's only going to get worse over time, where the impact is only going to get more severe, where it's just certain that over time you're not going to be able to work, don't walk away from it. You can bring a legal claim, and you should, because that money is yours. The insurance company is holding on to it. It is money you're entitled to because you've been paying premiums for years in order to make sure that you have this safety net available to you in the event that you become disabled from work. And now you are. So you should be taking that. You shouldn't be gifting that to an insurance company.
You mentioned that word in there, and we've done practically whole shows on this before, but you mentioned appeal. That might come our way regardless, right?
Yeah, so the appeal process, and we could do a whole show on this, you're quite right. The appeal process is something that the insurance companies have invented, essentially. It's not required, but what they're looking to do is they're looking to avoid having you talk to a lawyer. They don't want you talking to a lawyer, because as soon as you do, they're at risk of you bringing a legal claim, and when that happens, they lose control over the entire process. So when they deny a claim, or when they cut off your benefits, they're going to invite you to appeal, and most people will see that as the route that they're supposed to go. That's what it says in the letter. It says, my claim has been denied, but I can appeal, so that's obviously what I should do. Wrong. That's not what you should do. When you appeal, what you're doing is you're allowing the insurance company to continue to maintain control over the entire process. Once they stop paying your benefits, there is no reason to continue giving them that control. Take control, hire a lawyer, and bring a legal claim, and make sure you get what you're entitled to.
Does it just happen once?
Well, no, you can appeal as many times as they'll let you, and usually that can be 5, 6, 7 times over the course of 2 years. But after 2 years, your time runs out. You can't bring a legal claim anymore. And I guarantee you, after 2 years, the insurance company is going to have no interest in hearing your appeal anymore.
Time has run out here as well. Want to reach out? You can do so now that we're done for this week. 1-855-821-5900. That website we talked about, mydisabilityquestions.com. Free, anonymous anytime. Email we always go to as well, help@disabilityrights.ca. Lots of information, but you can use it all and continue on. Reach out to James and his team anytime. And we'll catch you next time on the Disability Law Show. Thanks for watching.